Yes, we are live now.
I quote, the Constitution is not a mere lawyer's document. It is a vehicle of life, and its spirit is always the spirit of age. B.R. Ambedkar. Unquote. A very good afternoon to everyone present here. Our esteemed Chief Guest, Honorable Justice B. Padmaraj, former Judge, High Court of Karnataka, and Professor M. K. Bhandari, CEO of ILTS, board members, and dear students. Today, we have gathered here virtually to celebrate 71st Constitution Day 2020. I, Nishchita PM, moderator for today's session, take this opportunity from the core of my heart to welcome you all to today's celebration. Now, I would like to call upon Mr. Abhishek Castro, Corporate Relations Coordinator at LawInternships, to give the welcome speech.
Good evening, all. I am Abhishek Castro, Corporate Relations Officer of LawInternships. Takes immense pleasure to welcome one and all to the LawInternships 71st Constitution Day celebration event and the soft launch of the journal Aperiogis. Before I begin my welcome address, I wish to quote the words of Baba Sahib Ambedkar. Baba Sahib Ambedkar says, Constitution is not a legal document. Constitution of India is the vehicle of life and the spirit of life of all the Indians. So with these words, I wholeheartedly welcome Honorable Justice B. Padmaraj, former Judge, High Court of Karnataka, Professor Dr. M. K. Bhandari, CEO IELTS, Mr. Shubham, Ms. Simi Varghese ma'am, Ms. Riddhi Jindal, Mr. Adil Junaid Khan, all the student coordinators and members of LawInternships, and all the participants to the 71st Constitution Day celebrations and the soft launch of our journal Aperiogis. Welcome you all. Over to you, Nishika.
Thank you, Abhishek. I would like to call upon Ms. Simi Varghese, Corporate Relations and Event Ed at Law Internships, to kindly introduce about Law Internships, the online law school. Over to you, ma'am.
Thank you, Nishchita. Good evening, everyone. Together we can and together we will. Yes, Law Internship started with a vision to help students achieve their dream internship with top-notch lawyers, law firms, corporate bodies, and such. We believe that true internship allows students to actively participate and not just passive learning. Today, we provide opportunities in the field of law for students pursuing their undergraduate and postgraduate programs. We assist students at every turn to gain professional experience as well as to hone their legal skills while being enrolled in a full-time program. It gives us immense joy to see that our mission to pave a path for the budding lawyers to be is becoming gradually and steadily. We are happy to see our students placed under able mentors. With that, this evening, I take pride in bringing you our vision for a full-fledged online law school, which shall provide extensive education service. The objective is to forge a credible platform for the students, law aspirants who wants to pursue and fulfill their educational requirements in a wholesome manner with practical exposure to relevant skills. The principles of law internship are coherent to its approach and performance. It is a response to the need of the hour, as is a personal effort from the part of a bunch of young professionals trying to provide back to the community. As mentioned, for education to be wholesome, it needs to be coupled with activities that will ensure active involvement of the law students. And Law Internships is one such organization which has arranged platforms that have branched out not only to legal internships, but also to national competitions and seminars by eminent jurists in the legal fraternity, certificate courses, law journal, placements, and recruitment. And we also have the University Connect program, which further branches out into two narratives: the orientation and internship program and the internships program alone. The school is unique and one of its kind, which focuses on unlatching to the law school to the law students, wherein they will get an opportunity to hone their skills outside a classroom environment, encouraging their holistic development. Over to Nishchita. Thank you very much.
Thank you so much, ma'am. Now, I would like to hand over the platform to Ms. Riddhi Jindal, Head Coordinator at Law Internships, to kindly introduce our respective chief guests.
Thank you, Nishita. A very good evening to everyone present here. I am Riddhi Jindal, the Head Coordinator at Law Internships and the moderator for today's interactive session. We have amongst us Honorable Justice B. Padmaraj Sir, former Judge, High Court of Karnataka. Sir enrolled as an advocate in 1969 and practiced for 13 years and 10 months. Sir joined Karnataka Judicial Service as District Judge in 1983 and promoted to the cadre of District Judge Super Time Scale in 1991. Sir had been appointed as the permanent judge of the High Court of Karnataka in 1994 and served as the acting Chief Justice from 29 November 2005 to January 6, 2006. Sir was also the president of the Karnataka Judicial Academy. We are privileged to have you here, sir. Today, Sir would be enlightening us on, has the Constitution failed the people or the people failed the Constitution? So if anyone has any queries or questions, you can raise your hand and we shall recognize you and unmute you, or you may write your questions in the chat box. So without delaying any further, let's begin the session for today. Over to you, sir.
Good evening to all of you, and in particular to my fellow students and internees. I am really proud to be in your midst on this excellent evening on an occasion like this on the Law Day. Friends, I regard it as a great privilege to be asked to address on the eve of celebrating 71st constitutional law by this organization. My tribute to the organizers and to the organization for providing such a wonderful opportunity to share my thoughts and views on a topic of my choice on the evening of my life. I would like to pay my tribute to the teachers of this organization who expend their lives on significant work. Their dedication bears testimony to the excellent products produced from this novel organization, produced or to be produced from this novel organization. Now to the topic at hand. Of course, I have chosen this topic deliberately, having read some articles in some of the newspapers. But before that, on this occasion, I would like to quote the words of N.A. Palkiwala from his book, We the People. And he begins his book with this introductory remarks. I just share with you, because this book was first published somewhere in January 1984. Now I'll read it to my countrymen. In fact, this book has been written only for the young readers. And he begins by saying this: to my countrymen who gave unto themselves the constitutions, but not the ability to keep it. who inherited a resplendent heritage, but not the wisdom to cherish it, who suffer and endure in patience without the perception of their potential. So this is how his book begins. To my countrymen, it's a very beautiful book. I would rather recommend to all of you to read that book with all interest and anxiety. Then, of course, so far the history goes, on the historic day of 9/12/1946, when the Constituent Assembly began its deliberation as to the structure of the Constitution of our great nation, the provisional chairman of the Constituent Assembly, late Sri Sachidananda Sinha, quoted the words of Joseph's story, and I quote, "The structure has been erected by architects of consummate skill and fidelity. Its foundations are solid, its compartments are beautiful as well as useful, its arrangements are full of wisdom and order, and its defenses are impregnable from without. It has been reached for immortality. If the work man may justly aspire to such a little, it may nevertheless perish in an hour by the folly or corruption or negligence of its only keepers. I repeat, it has been reared for immortality. Nevertheless, if the work of man may justly aspire to such a title, it may nevertheless perish in an hour by the folly or corruption or negligence of its only keepers, the people. Republics are created." These are the words which I commend to you for your consideration. "By the virtue, public spirit, and intelligence of the citizens. They fall when the wise are banished, and intelligence of the citizens. They fall when the wise are banished from the public councils because they dare to be honest, and profligate are rewarded because they flatter the people in order to betray them." Kindly see, these are the words which were repeated and echoed when the deliberations began on December 9, 1946. I would rather say that these words contain certain accurate prediction of our disenchantment with the present state of affairs and happenings in our country. The foundations of the Constitution have been shaken by the folly of the people, the corruption of the persons in power, and the negligence of the so-called intellectuals, which includes the legal fraternity also. The picture that emerges is that of a great constitution in a state of moral and ethical decay. If we are asked what the self-government after independence or after the constitution was framed, that is 7 decades of republic government has taught us, we must admit that we had the talent but missed the meaning. Something like this, we had the travel ticket but missed the bus. We have devalued the judiciary as we have devalued every other important organs of the Constitution. We have democracy without meritocracy, ignorance incompetence, and dishonesty are no disqualifications for high officers. The other day, I saw a write-up in the letters to the editor column of India, editorial letter to the editor of Hindu. It reads this. Of course, what I want to impress upon you is many a times, whatever the words that are uttered by the great people or how the great people conducts, probably it will be followed by the lower strata of the society. That is what Krishna also says in Bhagavad Gita. So there should be a model. Probably in that view of the matter, I would like to share this opinion expressed by one of the writers. The remark of the Chief Justice of India that the Supreme Court is discouraging Article 32 petitions. I repeat, the remark of the Chief Justice of India that the Supreme Court is discouraging Article 32 petitions is disturbing. The very language of the said article makes it clear that the right to move the Supreme Court is as much a fundamental right as the other fundamental rights guaranteed under the Constitution. The CJ's remark just after the issue of the arrest of a TV anchor only dampens hopes, despite Justice D.Y. Chandrachud's recent remarks on personal liberty. It is now left to the top court to re-establish the faith that the said TV author's case will not be a case of individual dispensation, but is also for all those who are undergoing arrest, trial, and detention. There needs to be a full bench to decide the issue of personal liberty in the case of such persons who have been detained for challenging the value system and seeking people's liberty, all the more urgent in the context of linked issues such as the CAA and Article 370 is concerned. Probably in this context, I will also read what appeared in the Hindu newspaper. What are the oral observations made by Justice D.Y. Chandrachud when the matter of the editor came before the Supreme Court is concerned? Of course, I will share it with you. The main observations are like this. That is, personal liberty is increasingly becoming a casualty in the country. These are the observations made by the Supreme Court judge who is an incoming or who is going to become the Chief Justice of India. So personal liberty is increasingly becoming a casualty in the country. People are now put in jail for a tweet. We are all traveling through the path of destruction of liberty. Kindly bear in mind, these are the words, the oral observations made during the hearing of the editor. People are now put in jail for a tweet. We are traveling through the path of destruction of liberty. You may not like his ideology. Left to myself, I will not watch his channel. But citizens are sent to jail. High courts don't grant bail. We have to send a strong message. These are the observations of Justice D.Y. Chandrachud, heading the bench, oral observations. Then he further said, during the day-long hearing, Justice Chandrachud referred to a recent case of a woman who was hauled up by the West Bengal government for a tweet. We are deeply concerned. These are the observations of the learned judge. We are deeply concerned. If this is how human liberty is persecuted, the Supreme Court has to be there for every person. Kindly see this. These words in contrast to what is supposed to have been stated by the CJI because the CA appears to have stated, which has been reproduced by the person, that is, the Supreme Court is discouraging Article 32 petitions is disturbing. Why it is disturbing is, it is in this context. We are deeply concerned if this is how human liberty is persecuted. The Supreme Court has to be there for every person. And you know, and you are well aware that so far as Article 32 is concerned, it is also one of the fundamental rights. We are getting cases personal liberty in multitudes. I am repeating, we are getting cases for personal liberty in multitudes. Our democracy is extraordinarily resilient. Our point is government should ignore them. Taunts on TV. You think what they say makes any difference in the elections? Justice Chandrachud observed. The court asked the Maharashtra government whether custodial interrogation, etc., is necessary. And ultimately, after a day-long hearing, the man was released on interim bail. But however, there is one more article which appeared in the editorial. This is what I expect from each and every person or each and every citizen, at least from the guardians of law. There is a very beautiful article written by a very senior advocate of the Madras High Court, and it makes a good reading under the title, Protect Our Republic, My Lords. This is directly appealing to the Supreme Court and each and every judge of the Supreme Court. This is how it reads, and I will also read the subtitle to attract your attention to this article is concerned. Protect Our Republic, My Lords is the main title. The judiciary's quick intervention. I repeat, the judiciary's quick intervention in the Arnab Goswami's case turns the spotlight on other serious cases that languish. I will only read the relevant portions here and there, not the entire article. I will just read because what actually appeared so far the arrest of the Arnab Goswami is concerned, and what happened subsequently after his arrest is concerned. The facts are brief. Mr. Arnab Goswami, Republic TV, a media group perceived to be supportive of the ruling party, was arrested by the Mumbai police on November 4, 2020 on a charge of abetting the suicide of Anvay Naik. The suicide note mentioned that the channel had not paid bills amounting to rupees 83 lakh, and this was a proximate cause of the act of suicide. The accused was remanded to judicial, not police, custody. He moved a writ petition for habeas corpus. Kindly see, he moved a writ petition for habeas corpus. Then before the Bombay High Court, wholly unusual, since that only applies to detention without cover of law. In this case, he should have moved the Sessions Court for bail or discharge and then come to the High Court if unsuccessful. Then the article further reads, the High Court heard his case for 5 hours on a holiday. Probably you are all well aware that it was heard on a Saturday. The High Court heard this case for 5 hours on a holiday and said exactly this on November 9. What exactly it said? Please go before the Sessions Court and apply for regular bail. Then Mr. Goswami did file such a petition. He filed a petition before the district judge. Strangely, he also moved the Supreme Court, and his case is listed on November 11. It takes up the whole day, and that evening he is set free and emerges pumping his hands in the air, much like a conquering public hero. 2 whole days of judicial time of top constitutional courts have been spent in deciding whether this one man should get bail when his case for when his case for precisely this relief was coming before the session judge the next day. As regards the release itself, suffice it to say that once a court thinks there is no tenable case for continued detention, no man should be held imprisoned. There is, however, the disturbing contrast between the breakneck speed of the Supreme Court in this case with other cases which involve large scale and serious violations of fundamental freedoms. And at the back of the discourse looms large two questions, almost too frightening to voice. Has the court done the one thing which a separate and equal judicial arm never does? And that is to cease being the counter majoritarian check to a powerful executive. Has the court abandoned its role of judicial review over acts of government, reducing itself to an arbiter of private disputes? I cannot but help recall what happened at Rashtrapati Bhavan when the then Chief Justice of India, M.N. Venkatachalaya, was sworn into his office in February 1993. I pause here for a while and say, so far as Justice M.N. Venkatachalaya is concerned, because I was elevated in 1994, just before his retirement, and he is my mentor also. Both when I was selected as a district judge, both when I was appointed as a permanent judge of the Karnataka High Court. So this is what he has stated. Kindly do observe that, see the difference between the two individuals or two top individuals making their observations in public. Here what is of import is, I cannot but help recall what happened at Rashtrapati Bhavan when the then Chief Justice of India, M.N. Venkatachalaya, was sworn into his office in February 1993. Prime Minister P.V. Narasimha Rao said that he looked forward to a cordial relationship between the court and the government. So on the occasion of his swearing in, these are the words spoken by another constitutional agency, the then Prime Minister of India. Then do you know what is the reply that he got from M.N. Venkatachalaya? Immediate response was, he received a riposte which can only be described as classical. He observed, he has written, Mr. Prime Minister, the relationship between us has to be correct, not cordial. Cordiality between court and government has no place in our constitutional scheme of checks and balances. I once again repeat, Mr. Prime Minister, the relationship between us, that is between the judiciary and the executive, has to be correct, not cordial. Cordiality between court and government has no place in our constitutional scheme of checks and balances. When comes another such Chief Justice of India, probably he is dreaming, when comes another such Chief Justice of India as the one who was created in Justice M.N. Venkatachalaya is concerned. Now, of course, he is very critical of the way in which the Arnab Goswami has been released on bail. And I just read a few lines here and there. Say, then further it is said, and in one case, a decision comes in after the issue of no longer survives. Of course, he is referring to Shaheen Bagh case also. It is not just every word what you say that is examined, because whatever that is uttered by the judges are being examined by the public. It is not just every word of what you say that is examined, but in what kind of cases you say it is important. Kindly see how beautifully it has been worded. It is not just every word of what you say that is examined, but in what kind of case you say it, as well as the cases where you say nothing. That all adds up to note the balance you hold between us, the people, and our rulers. So what when Venkatachala has observed is there cannot be any comradeship between the government and the judiciary. But here the author has expressed that all adds up to note the balance you hold between us, the people, and our rulers. It also determines another balance, that of power between you and the ruling forces in politics and government. The unstated major premise of judicial realpolitik is that your power comes not from Article 32 and Article 226. Kindly bear this. What he is saying is your power is, so far the power of the judiciary is concerned, it does not come from either Article 32 or Article 226, but from the public esteem and regard in which you are held. And that proceeds from the extent you act as our constitutional protector. In direct proportion stands that there are only the trappings. Then, of course, he has also uttered the words of caution. Following on the heels of the Arnab Goswami release comes the Attorney General for India's nod to book the stand-up comedian Kunal Kamra for contempt of court for his tweets about the Supreme Court in the instant scenario. Incidentally, this is the man the Ministry of Civil Aviation banned from flying for accosting and beating Arnab Goswami on a flight. What kind of message is being sent out here? This is exactly what I want to lay emphasis. When you say that Article 32 should be sparingly used, what kind of message you will be sending, especially in the context of the observations, oral observations made by Justice Chandrachud while hearing the bail petition of Arnab Goswami. Then he further, of course, explains so far the person is concerned is only a jester. Then speaking of the Attorney General, because he also speaks of the Attorney General, one hopes that he will soon revert to what he is constitutionally mandated to do, to appear in court in major cases of constitutional importance. He is our senior-most lawyer of constitutional vintage, with unmatched erudition and experience, and knows perfectly that he is the first law officer of the Union, not the lawyer of the government. Kindly say, not the lawyer for the government of today or party in power, a distinction that seemingly evades his deputy, the Solicitor General. Then, of course, the last para is of some importance I would like to bring to your notice to all, because this is how the public gazes when you decide certain cases and make the observations. May I present, my lords, this is an appeal to the Supreme Court judges as well as to the constitutional authorities. May I present, my lords, a solution. Extend the grace of your early hearing to Varavar Rao, poet, aged 80, suffering neurological and urological health issues, to Sudha Bharadwaj, aged 59, civil liberties defender, suffering hypertension, heart disease, and diabetes. They have been incarcerated from August 2018. To Siddiqui Kappan, the journalist from Kerala, detained on his way to Hathras in October this year. Take heed of the pitiable plight of Stan Swami, activist aged 83, suffering from abdominal pain and multiple falls in jail. He is unable to hold a glass because of Parkinson's disease. His plea to use a sipper, kindly see, his plea to use a sipper or straw in jail has been adjourned by 3 weeks to November 26. Probably this is the day to which it has been adjourned. And today we are observing the 71st Law Day also. So the matter has been adjourned awaiting for the law day so that some relief could be granted to him. Let their cases too be posted emergently before the same bench, which so instantly gave relief of personal liberty to Mr. Goswami, and let them be judged according to law, and then lead us on the path of constitutional purity so that our republic may prosper. I repeat, and this is exactly what made me to choose this topic, and then lead us on the path of constitutional purity so that our republic prospers. So these are the observations. I thought it fit to bring these facts on this law day as to how the lawmakers should view the things, and they must be bold enough, just like the senior advocate. I will also mention his name, I think, Sriram Panchu. A beautiful article which is written by him. We need such bold advocates to make such observations, in at least in the editorial, make it aware to the public. Many of us may not be knowing what exactly is happening behind the screen is concerned. So this is the reason with which I brought it to your notice. These words, according to me, contain an accurate prediction of our disenchantment with the present state of affairs or happenings. And especially so far as I would rather, of course, I can even go to the extent of quoting Justice Rajgopal, I am sorry, the then great leader, that is Rajgopalachari. He correctly visualized. Of course, ultimately he was very optimistic in his remarks. I will just read, because what he has written in his prison diary in 1922, because he rightly envisioned what is going to happen after the freedom is given to us. This is what he had said: the man who did not miss the meaning and implication of freedom was C. Rajgopalachari, who clearly foresaw what freedom without education, probably I will lay emphasis, without legal education, would bring in its wake. While in jail for civil disobedience, he made the following entry in his prison diary on January 24, 1922. I have just now read a passage which has appeared somewhere in before the Constitution was given, we have given to us. But this was in 1922. Kindly remember, exactly 100 years ago. So it's what he has written: elections and their corruptions, injustice and the power and tyranny of wealth, and inefficiency of administration will make a hell of life as soon as freedom is given to us. Men will look regretfully back to the old regime of comparative justice and efficient, peaceful, more or less honest administration. The only thing gained will be that as a race, we will be served from dishonor and subordination. Hope lies only in universal education, by which right conduct, fear of God, and love will be developed among the citizens from childhood. It is only if we succeed in this that Swaraj will mean happiness. Otherwise, it will mean the grinding injustices and tyranny of wealth. What a beautiful world it would be if everybody were just and God-fearing and realized the happiness of loving others. Yet, there is more practical hope for the ultimate consummation of this ideal in India than elsewhere. Probably he was not only a great visionary, but very optimistic. So probably I expect the same from all the legal luminaries as well as from the internees, that kindly remember or refresh your views with the words which are spoken to by the great people. They exactly foresighted. They were not astrologers, but they exactly foresight what is going to happen after the freedom is concerned. Now, therefore, having read all these observations, now it is up to you to think, evaluate, and prepare yourself for future. Why I am impressing all these observations upon you is only for this reason. Everyone will say that the access to justice is there. Then what exactly is the meaning of the word access to justice? See, so far as the Arnab Goswami is concerned, he was defended. His bail petition was moved by none other than the highest paid advocate Harish Sarve. Probably we charge 10 lakhs or 20 lakhs per hearing per day. Then so far as the access to justice is concerned, it should be available to every man in this country. Is it available? So I would rather say access to justice means access to good advocates also. Where is the good advocates available? In fact, when I have been taking classes in the academy, I used to impress upon the subordinate court judges with great respect, I should say. If at all, if any justice is to be done to a common man, it is only at the level of the subordinate courts. Thereby, I do not mean that the Supreme Court judges and the High Court judges will not do justice, but you don't have the capacity to have access or knock the doors of the High Court or the Supreme Court. Because all good advocates, they think that they are sold for money. Everyone, earlier I was hearing, so far our High Court is concerned, in fact, they used to charge in thousands. Now it is in lakhs. It is a boom period. Whenever a politician is arrested, probably it is a very boom period for the advocates of high stake. So when there is no access to the good advocates, probably there is no access to justice at all. Probably it is in this context, the former Attorney General has said that every senior advocate, at least 25% of his time should be donated or dedicated for the social services concern. Let them also take up the causes of the social causes and defend the poor persons also to get their rights also. So friends, imbibe the quality of right thinking and ability to think clearly. Exactly what I say. Imbibe the quality of right thinking and ability to think clearly. Adopt an attitude of reserve towards right ideologies. The soundness of an ideology is often in inverse proportion to the popular support it commands. So these are the things which I wanted to share with you. But at the same time, my simple advice to all the internees and students of law, I would recommend to you the habit of reading some good books, not only to pick up a good language, I would say the good legal language, but also to learn from those books as to how you should think. I would recommend to you the habit of reading good books to enhance your knowledge and skill. Reserve a particular time of the day to read literary works, including legal literature. I would recommend 3 books. Of course, whatever that occurs to me, probably our professor may enlighten you about some more books. I would rather say, because I have come across some of the books, that is, I would recommend 3 books for young lawyers as must-read books. Courtroom Genius, probably must have heard of the title of the book, which gives a detailed account of the variety of cases conducted and argued by Nani Palkiwala and the issues involved, including the constitutional issues. There is also a reference to Keshavananda Bharati. What actually transpired in the courts, it is beautifully reflected. I would rather say that instead of reading the book on constitution, if you read this book, you will get answer to all your queries. The second is the 5 volumes of Lord Denning. In particular, the discipline in law is concerned, because he has very clearly dealt with how the law has been reformed from the traditional law to the modern law is concerned. The third one is written by US Supreme Court Judge Justice Stephen G. Breyer. The book titled The Court and the World. This book examines the work of the Supreme Court in a globalized world. I read some excerpts, provided I am not taking away the valuable time. Just I will read only a certain excerpts from this interview, which appeared in a journal called as Legal Era. And I only read a few excerpts here and there to impress upon you as to how you should, because we are going for globalization. Our Prime Minister has been saying, Vasudhaiva Kutumbam, the whole universe is our family. Then we must be acquainted with the laws of the other nations also. So this is what he has stated. The Court and the World, the book widely acclaimed as original, far-reaching, and timely, examines the work of the Supreme Court in an increasingly interdependent and globalized world. Breyer, analyzing several key decisions of the Supreme Court, points out that as the world grows smaller, or to quote Thomas Friedman, flatter, the court's horizons have inevitably expanded. Issues that used to or could be considered as other people's problems are no longer considered as such. What happens in Thailand may very well have real consequences, monetary or otherwise, in Washington. And for that reason, the foreign aspect of the Supreme Court docket is on the rise. Breyer's book attempts to answer the following question: how can America's highest court decide American cases and interpret American laws so that they might work efficiently and in harmony with similar laws of other nations? Then he has further observed in his interview that if someone with a job roughly like me, like my own, facing a legal problems, roughly like the one confronting me, interpreting a document that resembles the one I look to, has written a legal opinion about a similar matter, why not read what the judge has said? I might learn from it whether or not I end up agreeing with it. It's a very beautiful observation made by the learned judge, and I should say that this is a must-read book for all legal internees. Then, of course, he also refers to some of the individual cases, which I am not going to refer. Then one important observation appears from his interview I would like to read. It also means if you read some foreign opinions, you don't have to read them all the time. But if they are called to your attention by the lawyers, you learn something. This is exactly what I say. That's exactly what has been said even in Mahabharata also. Gunakya matsarve. Why should we envy the good things even if it exists in the enemy also? That's why even though Duryodhana was supposed to be a bad man, but he had some good qualities. Then appreciate those good qualities even in a bad man is concerned. So they say why we should not learn something. Therefore, it is a circle. I think a virtuous circle. The circle of our profession is law professors and lawyers and judges. Kindly see how broad his vision is. The circle of our profession is law professors and lawyers and judges. The judges write the opinions. Kindly see, the judges write the opinions. The lawyers help them write the opinions. The law professors evaluate. Probably the law professor who is present here may evaluate me as to what has been spoken to by me. The law professors evaluate. Each reads the work of the others, and gradually we hope for improvement. This is exactly should be our attitude when the question of learning comes. Then the last passage I would like to share with you is, judges are generalists, almost all of them, and therefore they have to be able to solve legal problems that can touch on almost anything. There is a vast difference between a tort case involving a drug that someone says was not adequately checked and a case of human rights involving misbehavior in Ghana. For example, with the parties back in the United States, both could come before the court in certain circumstances. And that is why generalist judges depend not their own knowledge of everything, but how to deal with the arguments of the lawyers. It is the lawyers who have to understand. The trial lawyers are experts at being generalists. Then further he said, we did not have the civil war. What we did, we have slavery. We did have legal segregation. We had all kinds of things in this country, that is referring to America is concerned, but gradually we overcame some of them. And gradually the rule of law has taken hold. I expect that the rule of law has to take hold of this great nation also. That is what we are trying to do. Why? The alternative is you go turn on the television and you see people killing each other. That's a very bad way to solve the problem is concerned. I hope that day will not come when we see people killing each other. That's what is happening throughout the entire world. You have been seeing how protests are going on in several countries are concerned. So these are the passages, not of my own, but from the great people I have shared with you. Probably you have already found the answer to the topic that is chosen by me on this occasion is concerned. Please remember, Constitution has given us in bounty and it has not failed. Probably I will only conclude with these remarks, but it is not being properly utilized. No doubt it is being utilized only by good advocates for a better people, better placed people. We used it according to our own conveniences. Dr. Ambedkar poignantly remarked in the Constituent Assembly that if the Constitution, which was given by people and to themselves in November 1949, did not work satisfactorily at any future time, we would have to say not that the Constitution had failed, that man was vile. Hence, it is not the Constitution which has failed, the people has failed the Constitution, but it is the people who handle the Constitution who have failed the Constitution. I repeat, it is not the Constitution which has failed. If at all, anybody feels that there is injustice done to him, or what has been expressed by the senior advocate in protect our republic, then probably I will say, but it is the people who handle the Constitution who have failed the Constitution. We must go out in public to grant or to recognize ability, merit, knowledge, and integrity. It is the job of every guardians of law like you, the law interns. There should be a public debate as to how we can meet the crisis facing the country, not of pandemic COVID-19, but of moral, legal, and ethical crisis. To shut our eyes to the gravity of the situation would only invite focus of authoritarianism of the type which overran the country. Constitutional developments in our country are not a matter of concern to our own people alone, as has been rightly said by Justice Breyer. Constitutional developments in our country are not a matter of concern to our people alone. We constitute more than 1/7 of human race, and our choice in this regard will have an impact on the democracies of the world. Our Constitution has a very meaningful preamble which reflects the pledge contained in the Objectives Resolution of 1946 to guarantee the basic human rights. We made our choice in 1949, and after 70 years, we have to say whether we have made a right choice and or to make the other choice. But whatever be the choice, it should not be done at the expense of the human spirit. At this point, I am reminded of the words of the author of children's Ramayana. Why is epic so powerful and meaningful always? In fact, I got attracted to that passage. Of course, it also some interview appeared. There is a book, I don't know whether you are aware. There is a book written especially for the children Ramayana by none other than Arshia Sattar, a Muslim lady. And she says how important Ramayana is, though of course, I mean to a certain extent, I may be out of context, but I feel I'm not out of context because you know that so far the original copy of the constitution which is kept in Delhi at the parliament contains all this, probably the pictures of all Ramayana is concerned. That's what has been exposed. And here, of course, there were certain questions which were posed to her. What made her to write this book only for children? Then one of the questions that was posed to her is that do you think the younger generation can relate to the ideals of Rama? Probably now this is the name which has been broadly misused by the politicians, and probably it has got its own sanctity, which sanctity to a certain extent has been polluted by these people. So this is the question to her. Do you think the younger generation can relate to the ideals of Rama? The answer is anybody who takes the trouble to read the story for themselves, whether they live in Timbuktu or Iceland, will feel connected with Rama. Not because he is the ideal man, but because he faces universal human problems. How do I do the right thing? Kindly see, probably these questions must occur in your minds also. How do I do the right thing? What does it mean to be good? And how do I respect my elders and be true to myself? What does love mean? And what are its limits? I think our younger generation in India who are experiencing social change at an accelerated pace are grappling with the same questions. They need to encounter a Ramayana that is not teaching them, but one that is helping them to articulate the question that they face. I repeat, they need to encounter a Ramayana that is not teaching them, but one that is helping them to articulate the question that they face. Then another question, of course, I'm quite long. Can Rama be the role model of today's generation who believes living life in the fast lane? That's exactly what is happening. The most beautiful thing about the Valmiki Ramayana is that Rama can be who you want him to be. If you look for God, you will find him or her. If you look for a human being who is trying to do his best in the worst of all possible circumstances, you will find him and you will find her as well. Sita deals with as many difficult situations as Rama does, perhaps even more than he does. Rama and Sita are finally wrought characters in a magnificent story. A story suggests to you how hard it is to be good. Kindly see, and I repeat, probably in the present days, how hard it is to be good. Rama and Sita are finally wrought characters in a magnificent story. A story that suggests to you how hard it is to be good. Rama acts, he thinks before he acts. Kindly note this. Rama acts, but he thinks before he acts. He considers the consequence of his actions and takes a responsibility for what he has done. That is a reasonable and admirable way to live your life. We can learn from that, whether we live in the fast lane or not, whether you are younger or older generation is concerned. Then, of course, they say, is there any lesson? What I have tried to do, in all honesty, is to present a story in such a way that younger readers will notice that there are problems and difficult moments. There are points in the story when children will be uncomfortable. They will ask, why did you do that? What does this mean? We have to ready to enter the discussion with them. The onus is on us to adults to tell the truth as we see it, to negotiate the whirlpools of confusion and be ready to surrender to our own discomfort first and lack of certainty about how we understand the characters and the story. So just like that, the holy book, what she has said, probably I would also say that yes, same thing probably, whatever that is said of Ramayana by that great lady who has written for small people, then the same thing holds good. The same can be said of our constitution, a holy book. A glorious beginning must not have an ignominious end. If freedom under law survives in our country, it is only because the fundamental rights in our constitution and the outstanding independence of our courts. And I can also add, with access to the good advocates like you. So with this, I conclude, but not before I express my gratitude to the organization for having enabled me to be in your midst and to revive the hope that you will certainly carry forward the mantle of our constitution in its right human spirit and make the nation a proud and great nation. I can hope for no great reward than that the young listeners like you will find something in this speech to inspire you with an earnest zeal for protecting our own great nation being misused by a few greedy and corrupt people. With this, I conclude and thank you very much for your patience. Thank you very much.
Thank you, sir. The students must have taken valuable insights from the topic today. So we have received few questions from our participants as well as our YouTube subscribers. So if you would allow me, shall I proceed with the question session, sir?
Yes, I will pass on the question to our professor because he is the person who can enlighten us. Just now I quoted by saying that the best thing to evaluate is only the professors. Yes.
Yes, sir. So there's a question. Kindly unmute you, sir.
Okay.
Yes, so the question is, sir, your take on a previous Supreme Court judge, Ranjan Gogwani, sir, issue on being the judge of his case on sexual harassment against him, violating basic natural justice law of nemo judex in causa sua.
Yes. 1 minute. Huh?
Yes, sir. Sure, sir.
Supriya. Only 1 minute because something is wrong with my video. ನನ್ನ ಮೊಬೈಲ್ ತಗೊಂಡು ಹೋಗ್ತೀಗ ಅಲ್ಲ ಮುಗಿದಿಲ್ಲ ಅವ್ರಿನ್ನು ಇದ್ರೊಳಗಿದೆ ಕ್ವಶನ್ಸ್ ಕೇಳ್ತಾರೆ
ಡಿಸ್ಕನೆಕ್ಟ್
ಅವರು ಅನ್ಮ್ಯೂಟ್ ಮಾಡ್ಕೊಂಡ್ರೆ
Sir, we can
you
see
are
you.
unmute, sir. You are unmute. Actually, we asked MK Bhandari sir to unmute when he was speaking. You are unmute only.
Sir is audible.
Yes,
Sir,
sir.
you are very much audible. Please, you can
Yes, sir.
respond. If you have heard the question, you can please respond.
Okay. Shall we start with Vandari sir's speech?
Yes, sir.
No, let him. But Justice Padmaraja sir,
Yes.
you are already unmute. We can listen you. You can please respond to the query.
Yes, sir.
Yes, please.
It was about the Ranjan Gogoi, if I am correct.
Yes,
Yes,
sir.
yes, yes.
Against
He
the
absolving himself against
Uh-huh.
the charges of so-called sexual harassment.
Yes,
He constituted a committee and then got him absolved.
yes.
yes.
What is the question relating to that?
Sir, your take on our previous Supreme Court Judge, Ranjan Gogwani, sir, on being the judge of his own case of a sexual harassment case against him, violating the basic natural justice law of nemo jurex in causa sua.
Yes. The answer is already in the public regime. Isn't it? It is not for me to answer. It is not proper also to comment on those issues, because I find that the answer is already there, because a lot of discussion and debate went on that. Of course, the basic thing is that one should not be a judge in his own case. And of course, everyone has noticed in the public realm that when the case was taken up, he was also present. And of course, he said he did not participate, but he was very much there, physically present. So you can draw your own inferences. So it is not for me to judge.
If you permit, I can just add what the great Shakespeare drama Julius Caesar says, that is, Caesar's wife must be above board.
Yeah.
So it is sure, yes. I don't mince word. In my book, I have already written so many things.
Very good, sir.
The judges must, what we say, justice should not only be done, but must appear to have been done.
Yes.
So in this case, it was very unfortunate, and the matter should have been handled in a very impartial manner. But it's unfortunate.
But the story further goes that immediately on the verge of his retirement or so, all those persons have been restored in service. And then that goes that whatever allegations that are made against that lady and her relatives was found to be false. There you can draw your own conclusion with what is verdict, guilty or not guilty.
No, sir, the question is not guilty or not guilty. The question is of how to deal with the issue.
Yeah.
The issue could have been dealt with more impartiality, fairness. The fairness. What is justice? The fairness in action.
Yeah, that's correct.
Anyway, there are many such issues, sir. There are many such low tides in the annals of judiciary. And the worst thing, which I think, if you permit me, the 4 sitting judges during court hours going to a home of a judge and conducting a press conference alleging against their own brother Chief Justice in the name of democracy, that because democracy is in danger, so we have come out. This was something I don't find words to say it. Nothing could be, that was the lowest ebb where the highest court honorable judges could go. They could have gone to the, I wrote number of comments. They could have gone to the President of India, who is their appointee.
That is what is happening
that we
now.
have an issue with the current Chief Justice and kindly resolve it, you being the head of the state. Instead of going to the press, and that too during the working hours. I wonder whether they took the leave or not.
But they were not held up for contempt.
And one of them later became the CJI also. Anyway, these are many issues, but still we respect our judiciary and its independence. And it is because of the independence of judiciary, some aberrations are here and there that our citizens are enjoying the civil liberties and fundamental rights because of the independence of judiciary. Ultimately, it is the institution who can check the arbitrariness of the governance. So that way we salute our judiciary also. Yes, please.
Yes, sir.
That is what is happening, especially when there is a open letter written by Justice, the Chief Minister of Andhra Pradesh. very recently.
Yes, yes.
Nimsha
Jagan
Ipatti,
Reddy, Mr. Jagan Reddy.
Jagan Reddy.
Yeah.
See what is
No.
happening. Probably this exactly what made me to choose this topic, whether
Yeah.
the constitutional crisis or human crisis.
No, this is the impropriety on behalf of the executive, on behalf of the chief minister, writing a letter and then making it public.
Yeah.
Yeah. Anyway, yes, please.
And
Yes.
the Attorney General rightly said that since the matter is already in the court of the Chief Justice, I don't want to give my opinion whether it should be hauled up for contempt or not.
Mm-hmm.
So shall I proceed with the next question?
Please.
Till what extent do we have the right to criticize, the need to decriminalize the contempt of court? The law from which we derive, that is English law, is not a criminal crime in England. Shouldn't we adopt to such freedom fit for a democratic nation?
Yes. Even the makers of the Contempt of Court Act is concerned, that is UK, they have abandoned the contempt of court itself. And probably you must be knowing that there is a magazine called as Law Quarterly Review in UK that always criticizes almost all the judgments of the highest court, and they want to point out the loopholes or flaws or the grave mistakes that are committed by judge in deciding the cases are concerned. I would rather say it is high time that we must also dispense with the entire act itself, the Contempt of Court Act, which acts always like a Damoclean sword on the head of each and every person. This is what makes people to be afraid. But there are people, just now I read about the article written by a senior advocate. They make it bold to come before the public and express their views. But I am left to myself. I would rather say that Contempt of Court Act should be removed from whether from the Constitution or from the different act itself. Yes, please.
So we're done with the question.
I would like our professor to enlighten me on this point also.
Sorry to interrupt, sir. Even I have a question.
Yes, please.
To Justice B. Padmaraj, sir.
Yes.
So as we have so many cases pending already in the case, more than 4 crores cases are already pending, 4,000 crore cases. So isn't it justice delayed is justice denied to them as well? So what can our judiciary do to do the fast trial? We have fast courts, but we know how it works. It takes several years for any matter to reach its decision. So what can a judiciary do to fasten its pace?
Probably in this context, there is also a writ petition filed before the Supreme Court, and fortunately, it has been entertained also. When Justice Thakur was the Chief Justice of India, there is an alternative has been suggested because he filed a writ petition to the effect that let there be final court of appeal at each center like south, east, west, and north, so that people can have easy access, and only the core constitutional matters will be taken by the Supreme Court, just like in United States of America. So probably the other matters will go before the other authorities are concerned. Why I am saying so is, if you go through any journal, what is it that the Supreme Court judges have been doing? They are doing nothing but the work of the trial court, CPC matters, CRPC matters, IPC matters. So they should reach a finality at some level. That is what we call it as final courts of appeal at each and every zone. And that writ petition is also pending before the Supreme Court. If they take up that issue and makes up a point that such a thing should be created, probably the government will not come in the way. And it will be a great relief to this nation. Because at least there will be a finality so far the other appeals are concerned, they will reach in time. And only the core constitutional matters will be taken up by the Supreme Court. Not that they will be doing the work of a magistrate or a session judge at the highest level is concerned. Probably this is the answer that I could give to your question.
Thank you, sir.
Thank you, sir. Participants must have taken some insights. So, moving further, we have amongst us Professor Dr. N.K. Bhandari, sir. Professor Dr. M.K. Bhandari, sir, is the CEO of the Infinity Law Tech Educational Services. Sir is the visiting faculty of various eminent institutions such as NLU Assam and mentor on blockchain and cryptocurrencies. Sir has more than 40 years of experience of professional and academic in teaching, research, administration, and exploration of innovative teaching skills and curriculum design. Sir has expertise in team building and great networking with legal scholars and setting up of legal processes on highly transformative technologies such as blockchain, fintech, and artificial intelligence, and there are many more. Sir has made large contributions in the field of law through his publications on topics such as legal aid and paralegal volunteer scheme in India, basic structure of the Indian Constitution, a critical reconsideration, and there are many more publications as well. We are honored to have you here, sir. Today, sir would be throwing some light on revisiting Indian Constitution. So if anyone has any queries or questions, you can raise your hand and we shall recognize you and unmute you, or you may write your questions in the chat box. Without delaying any further, let's begin the session for today. Over to you, sir.
Thank you, Riddhi, for your generous introduction. I think one line is sufficient to introduce me, that I am a learner. I am a crazy learner and I am a student of law. Still have a hunger for exploring the new areas of learning. Anyway, thank you. Honorable Justice B. Padmaraja, all the team members of the innovative online platform for legal education and legal internship, law internship, and dear participants, thanks to the technology, the interactive communication technology that we are meeting during this global crisis of COVID-19. It indicates that necessity is the mother of invention, and every challenge brings an opportunity to explore the new areas. So with this online meetings, online programs, seminars, webinars, we have come to a new normal. Now this has become, it seems during last almost 10 months, it has become a new normal. And it is a technology based learning. And I think this is going to stay for a long time. And we also at our ILTES Global Online Academy, of which Abhishek is a member, have started several innovative programs of internship in the area of law and technology, and conducted global summits, huge global mega summits. And currently we are conducting 2 international certification courses, and Abhishek Castro can share details with you. And I also invite all of you to be a part of our global academy. Those who are willing can write to me, and I will share all the necessary information how you can be a part of this global academy and contribute in our journey of learning. With these words, I have the benefit of listening to the learned views of Honorable Justice Padmaraja, based on his experiences, based on the real life experiences in the functioning of judiciary, in the functioning of the press, in the functioning of the government. Definitely, there are many issues, and he has portrayed the other side, or I would say the darker side of the functioning, through which we can have many lessons to learn. Friends, I will deal with briefly with the Constitution, how I understand what I understand. My one book, The Basic Structure of Indian Constitution, the image was just shown, is perhaps the only book which was published in 1993, in which I have disagreed with the ratio of Keshwanand Bharati case after a detailed critical research which is reflected in that book. Anyway, let me first of all pay my humble tribute and salute to all the genius members of our Constituent Assembly who gave to us this wonderful constitution through which we have traveled in last 70 years. We have been able to successfully nurture our democratic governance, constitutional governance, and we have been able to protect the civil liberties, human rights of our citizens. And also, the Constitution has given us an opportunity to make a progress, socio-economic progress in the diverse field of the life. But let me understand, let me share with you what the Constitution is. How should we perceive about the Constitution? In my opinion, the Constitution is not just a fundamental charter of governance. Constitution is a dynamic instrument. It reflects the hopes and aspirations of the people. And these hopes and aspirations have been placed in the preamble of the Constitution. We, the people of India, what we want: justice, socio-economic, political, equality of opportunity, freedom of speech and expression, and all these lofty goals which have been put in the preamble. And the preamble was based on the objective resolution then Prime Minister Jawaharlal Nehru moved in the Constituent Assembly. Based on that objective resolution, the preamble was adopted, and later on in 42nd Amendment, it was also amended to add socialist, secular, and other terms. So preamble, what we call, is a mirror, is a gateway to see the Constitution. Another thing which I want to share with you, that according to the learned international scholars, Ivor Jennings, Granville Austin, The Constitution of India, Cornerstone of a Nation, a great book, a great commentary on the making of a constitution by Granville Austin, Oxford scholar. Our great writers like H.M. Sirvai, Nani Palkiwala, Constitution Defaced and Defiled. So there are many commentators, many writers who have seen Constitution not just as a compilation of legal text. Constitution is much more than that. Constitution is a sum total of the constitutional philosophy. Every constitution has its philosophy. That philosophy is based on the socio-cultural ethos of a country. What may be right for India may not be right for USA. What may be right for USA, where they say the right to bear arms is a fundamental right. This right to bear arms, which is a Bill of Rights, Second Amendment, may not be good for India, the country like India. So every constitution has its constitutional philosophy. And that constitutional philosophy emerges with the socio-cultural, religious ethos of that country. So there is a constitutional culture. Then there is a constitutionalism. Constitutionalism means our commitment to the principles of the Constitution. Constitutional conventions, we all know as a student of the constitutional law that the whole British constitutional law is based on conventions. They are well-established conventions. It is not a written constitution. It's an unwritten constitution, supplemented with certain acts. So, for example, in our Constitution of India, we still follow the constitutional conventions. When it comes to the parliamentary democracy, the Prime Minister is appointed. Article 74 says the President shall appoint Prime Minister. It never says that the leader of the largest party in the lower house shall be appointed as a Prime Minister. It says the President shall appoint the Prime Minister. But the convention says that the person who represents, whose party is in majority in the lower house, that is Lok Sabha, and that party elects their leader that will be appointed. And in case of no clear-cut majority, then there are certain discretion with the prime minister, president. So we have seen some such cases. So this is a constitutional convention. If a party is defeated in the parliament on vote, then it will step down. Nowhere it is written, but it is a constitutional convention. So constitution, as I said, is based on constitutional conventions, constitutional philosophy, constitutional culture, and the doctrine of intent. Whenever we find any difficulty or whenever we interpret our constitution, we look to the intention of the makers. That is the doctrine of intent. What they wanted when they enacted, they approved that particular article of the constitution. What was their intention? So it is a doctrine of intent. Or so all these together, they create a body polity of the constitution. As Honorable Justice Padma Raja said, that it is we who have failed the constitution, and constitution has not failed. To great extent, it is true. Because while functioning with the constitution, while following the constitutional mandate, we have not understood the letter and spirit of the constitutional provisions or the doctrine of intent. I may give you just two examples to support my claim. One is reservation. Initially, the reservation was only a tool or as a technique for uplifting those deprived class of the people for centuries because of the Varna Vyavastha. They were deprived from the mainstream, and when constitution was adopted, framed, it was thought that those people, like scheduled caste and scheduled tribes, they must come into mainstream because equality is the cornerstone of the constitution. Equality before law, equal protection of law, egalitarian society, equality of opportunity, that is the main rule of law. These are the basic fundamental creeds of the constitution. So they were given representation for first 10 years in the bodies, that they will have a certain reservation in the representative bodies, so that they can also play prominent role in governance of the country. They are not just isolated, they come into the mainstream of the governance. That was the original purpose. But later on, we extended this reservation through First Amendment, Seventh Amendment, and other amendments to jobs and admissions. We further expanded this reach of reservation for OBCs. We created OBC, other backward classes. Then within other backward classes, we created another creamy layer and non-creamy layer. And now we even went up to offering reservation on basis of religion. In Andhra, the Muslims were given reservation, which was struck down by the court. So if we read Article 15 and 16, original Article 15(1)(2) or 16(1)(2) regarding public employment, there was no provision for reservation, but it was added later on. Not only it was added, but it was constantly increased. And finally, in Indira Sahani's case, Supreme Court came out with a mandate that upper limit of all reservations put together should not exceed 50%. But even that was not followed. If you, one of my friend and teacher also, because he taught me also, he is now late, Justice Dr. Bharatiya, Professor Bharatiya, his book on freestyle reservation, he calculated that even in the states like Tamil Nadu and other states, the reservation goes up to 67%. So much so. Now, the states are making reservation on the basis of domicile. Though there is a provision in the constitution that the residence condition of what we call mulki rules, condition of residence or domicile may be there, but it is further going to, I would say, with all due regards to the reserved communities, we have nothing against them. We want justice for them. But the way in which reservation has been followed, it has become highly a political issue. It's a constitutional politics, I would say, not the constitutional spirit, letter and spirit. It's a constitutional politics. In the name of constitution, our parties, political parties are doing politics. So there we have failed because we could not properly implement the letter and spirit of the constitution. The intent of the framers of the constitution was not like this. In fact, Baba Sahib Ambedkar was not in favor of these kind of never ending or ever expanding reach of the reservation, because it is dividing the society. There are other fallouts of this kind of reservation. In America, Justice Padma Raja referred about Justice Stephen Breyer. I had the privilege of, he was my mentor in a Salzburg seminar in 2001, and I have a photo I can share. Next to me is Justice Stephen Breyer, and I presented my book, this basic structure of Indian Constitution, to him, and he sent a letter from the Chamber of Justice Stephen Breyer. I could not just trace it out right now. So he said, I learned a lot about the Indian Constitution after reading your book. So that was a great compliment for me. And for 12 days, we were together at Salzburg in 2000, and he was our mentor, our faculty there. So in America, there is affirmative action. They provide facilities, they provide all economic, socio-economic support, but not the reservation, the vertical and the horizontal reservation as we provide. So that is one example. Second example I would like to give is ordinance making power. Article 123 and 213 for states, 123 for union. This power was given to be used sparingly when parliament or the legislative assembly is in not session and there is an urgency because country is to be governed by rule of law. So if you need a law, emergent law, the executive can frame an ordinance, president will approve it, and later when the parliament meets, then either it has to be approved or it will die its death. If you remember, D.C. Wadhwa, a great political scientist, wrote a book under the Gokhale Institute of Economic Studies, Ordinance Raj, a fraud on Indian Constitution. And that was in the backdrop of the ordinances which were promulgated and re-promulgated in Bihar. So every one ordinance was promulgated again after assembly was suspended, re-promulgated, and this way the whole 5 years the ordinance came. There were some amendments made later on. So that is another example. This was a power to be sparingly used. And third example, and as per my information, from 1949 or so you can say 1950, when the constitution came into force fully, till 2020, 750 times ordinances have been promulgated. That is, I'm talking of union, not of the states. States figure I don't have. Even during our present government, the then late President Pranab Mukherjee Da, he also expressed his displeasure the way in the initial years of the present government, the ordinances were promulgated. He said this is not a good practice. You go to parliament, get the law enacted by proper legislative procedure. So that is, again, this was never the intention of the makers of the constitution to bypass the parliament, to dilute the sanctity of the parliament. And third, 356, President Rule. Ambedkar himself said that I wish, I quote him, that Article 356 is a dead letter. We are putting it in the constitution, but it will be a dead letter. I wish that it will be a dead letter. And as per our figures we have, as of now till 2017, the last one was in Uttarakhand when I was there as a dean and director and pro VC in the university, a private university. 216 times the president rule has been imposed, a provision which was supposed to be a dead letter. And during the former late Indira Gandhi regime or during later Janata regime, 9 assemblies, 10 assemblies were at one go, in one stroke, they were dissolved because they were not in consonance with the ruling government. That was never the intention. So this is how we have our rulers, whosoever they are. We are not concerned with any political party. We are students of the Constitution, and we have to appreciate the Constitution and its implications as a student, as a scholar, or as a jurist. So the way in which these provisions have been applied or used for political gains compel us to rethink whether we need a second look at our Constitution. The Constitution is not a sacred document like Gita or Quran or Bible or Ramayana. No, the Constitution has to meet the challenges of the every generation. What may be fine with one generation may not be fine with next generation. Today, we are in Industry 4 stage, which is predominated by technology. Today, we are in the midst of digital transformation. Now, during this COVID, the courts have also shown the resilience and online hearings, which I think might never be thought that the online dispensation of justice would be a part of the Supreme Court or all other high courts and other courts, but that is we have seen. So we have to adopt, we have to be dynamic in our approach. We cannot be static. So also the Constitution should also reflect the hopes and aspirations, the challenges and the opportunities, and accordingly, wherever necessary, we should amend the Constitution. Now, let me tell you, we are the largest democracy in the world. US is the oldest democracy of the world. Our Constitution, as we know, has seen, originally it was 395 articles, 8 schedules. In course of 70 years, the basic articles are still 395, but sub articles and other articles, if we see, we cross 500. The one article 243, that is panchayats and the nagar palikas, 243 A, B, C, D, E, Z, F, J, what not. I wonder whether this is how the Constitution is drafted, whether the Constitution should have all these things. I have with me the copy of the American Constitution, which was presented to me at Salzburg which is autographed by Chief Justice Warren Burger on the 200 years of the Constitution of America. It has got 7 articles. 7th article is a enforcing article that we adopt this Constitution. 6 articles, few sections in each article. And in the history of 200, you can say from 1787 to now, only 26 amendments. Only 26 amendments. The last amendment was made in 1971, 30 years back, almost 30 years back. So how durable law they have given to the country. It is the flexibility of the Supreme Court in interpretation. It is the flexibility of the Congress, US Congress, in adopting to the changing circumstances that they have molded or remolded the constitutional interpretation, retaining its spirit and letter. This is the technique. Again, our judges always say, with all due respect to Honorable Justice, that we are less in number. Definitely, we are a population of 130 billion people. And we need more judges, more courts, no doubt about it. We have 33 judges now, or 35 Supreme Court judges. In US, from 1787, there were 9 judges. And today, there are still 9 Supreme Court judges. And interestingly, all these 9 judges sit together. The Supreme Court is not fragmented in division bench or full bench of 3 judges or 5 judges or larger bench of 7 judges. No. All matters are heard by all the 9 judges, and the junior most judge gives the opinion first, so that suppose the Chief Justice gives the opinion, they think the junior most judge might be influenced. So in order, the junior most judge gives opinion first. I had the rare privilege of appearing before the mock session of the US Supreme Court in Salzburg, where we conducted a mock session of the US Supreme Court, and we were made aware by one American lawyer that how it functions, how you have to argue. You get half an hour in the first round, and as a counter, again half an hour to argue. Not that days together you speak on. So this is how they decide. They admit hardly 175, maximum up to 200 cases they call certiorari granted. And they dispose 150 to 60 cases every year. So reaching to the Supreme Court is a very tough task. And this is the judicial clerk concept of judicial clerk, which our Supreme Court and High Courts have now introduced, has come from US. The top professors of the universities, they feel honor that he or she is a judicial clerk of justice so and so. And they do a lot of research work, and they assist judges in writing the judgment and doing the necessary research work. What I mean to say is that we can learn from the experiences of other countries. Now today we had 12 schedules, 104 amendments in the period of 70 years, and basically 395, but sub-articles, as I said. So what I think is that we need to relook at our constitution. What we have to make it smart. We have to delete the unwanted provisions which are not there or whose purpose has been fulfilled. I'll give you the temporary and transitional provisions. Can you imagine a constitution writing an article that there shall, while the Andhra and Telangana were divided, it was written in the constitution that there shall be a central university in the Andhra place. Is it a provision to be written in the constitution? This can be done through an agreement, but no, the political parties at that point of time might have ensured right in the constitution. We do not believe you, so give us a constitutional right to have a university. If this is where we develop our constitution, I wonder. So I have identified again that in reservation, we need a second look to Article 15. The reservation has been extended to promotion also. When it comes to judiciary, they say no, there cannot be any reservation in judiciary. Why? It is also part of the state. There is Article 335, the merit provision, that there should be, the merit should also be respected while granting reservation. There is no reservation in the defense forces because there we say that yes, there is a merit. There is no reservation in other top ISRO and all these things because there they invoke the Article 335. So we have to relook. Please do not misunderstand me. I'm not against reservation. But I feel, based on my experience of learning about the Indian Constitution as a humble scholar, that we need a thorough relook to the whole jurisprudence of the reservation, and in a non-political manner, not in a political manner. Again, as I said, ordinance making power, president rule. Do we need the provision like 356? Is a point, because it's an encroachment on the federal polity. S.R. Bombai's case, Sarkaria Commission, they have given several important recommendations, and we should seriously consider it. And even we should, in US, there is nothing like 356. No, the center cannot, the federal government has no power to abolish the life of the state government. There, the state governments have their own state constitution, and they are very powerful. So the way in which we have nurtured our federal polity, so we are quasi-federal. We are union. Basically, in my book, I have seen from apex, we are unitary polity. So this is what we need to think. Then the basic structure doctrine. To my mind, although the Supreme Court very jealously guarded, and while it turning down the National Judicial Appointment Commission, they said it is an independence, it's a violation of independence of judiciary. I wrote, I fail to understand how the appointing power or non-appointing power although it was fairly drafted, or some amendment could have been made where Chief Justice has a very important say, how appointment or non-appointment reflects on the independence. To my mind, please correct me, sir, the independence is in functioning, not in appointment. When you are discharging judicial function, you are independent of any external pressure, whether it is from the government or anybody. That is the independence. As sir said that I think we will have a complementary relationship, or then Justice M.N. Venkatachalaya, a great judge, I also bow my head to him, that no, we want a correct relationship and not a complementary relationship or cordial relationship. Yes, the judges must decide without any internal or external pressure. It is not the appointment process that determines their independence. It is the discharge of the judicial function that determines their external. And again, you see how independence of judiciary is compromised by government by offering certain plum positions post-retirement. The Honorable Justice Ranjan Gogoi was offered Rajya Sabha seat. I wonder whether a person who has been Chief Justice of India, the constitutional Chief Justice of India, administers oath to the President of India, the first citizen, head of the state. He is after retirement sitting in Parliament along with all these people and being a part of the all noise and all hue and cry. Something very, very baffling to me. Anyway, that is for him to decide whether he should have accepted this. Then commissions. In fact, in my opinion, no Supreme Court judge after retirement should be given any position. Any position. That then he can be, because otherwise they compromise the freedom. We know it, everything, everybody knows it. Otherwise, how could a Supreme Court lawyer dare to write an open letter to the Chief Justice, Justice Bhushan, Santi Bhushan, and then his son, that there are 8 Supreme Court Chief Justices who have been found corrupt, and he has given in sealed cover the names. How could a lawyer say? How could a lawyer dare to say who is practicing in the court? And recently, the Mr. Bhushan, he said, okay, I will not. Initially, he said, I will not say sorry. Later on, the Supreme Court, just to save, is a face-saving device, said, okay, we impose a 1 rupee fine. Will they do it for another case of contempt, similar case of contempt? Is it not the rule of law, equality before law or equal protection of law that should apply here also in other cases of contempt? That nominal. I remember that lady who was fighting that case, Narmada Dam case, Arundhati Roy. Arundhati Roy was punished for contempt of the court, and the final, after she refused to apologize or seek an apology, and finally it was, the punishment given was that till the rising of the court, you are punished. So she remained sitting outside the court till the rising of the court. When the court was closed, he came to the press and said, my lord, the dignity of judiciary or the independence of judiciary will not be protected by using the contempt or punishing. It will be protected by the quality of justice you administer. So anyway, please forgive me for my opinion. One may not agree with me, but I think the judicial reforms are very important. Not only the disposal of cases. Disposal of cases is a major challenge before the judiciary and the legal fraternity. But judicial reforms are very much needed, and we have to evolve a more transparent, a more inclusive system of appointment, so which will instill the confidence in the judiciary, which is essential. As I said, the independence of judiciary, if you ask me, is the most important pillar of the constitutional democracy. If judiciary is not independent, I think, yes, please. Please unmute you. Unmute. Please unmute your mic. Sir, unmute it. I could not hear you. I could not hear you, sir. Sorry. So I seek forgiveness for whatever, if somebody in my comments or my observations hurt somebody, then I would simply come to 2-3 points and then conclude, because already a lot of discussion have taken place. I wonder, the anti-defection law. This is again a classic case of how we have defeated the very purpose of 10th schedule by coming out with the alternative route. You resign and then you again contest. You resign and topple the government. This is what happened in Madhya Pradesh. This is what was happening in drama happening in Rajasthan also recently. So as I said, I'm not against any party. Please don't misunderstand. But what I am saying, that how we are making mockery of our constitution, how our political parties or the ruling parties, those who have a responsibility to run the constitutional governance, they are making mockery of the provisions of the constitution. So the anti-defection law again needs a relook. And similarly, the election commission, because systematically we have seen the institutions are backed with the people of the choice. Those constitutional institutions, they are packed with the people of their choice. And then the constitution becomes the casualty. So these practices should be stopped. And I think here, again, I would say, ninth schedule is a classic example. Ninth schedule, which represents Article 31B, that there are almost 285 laws which have been, that is a protective umbrella. All the laws, mainly the Land Reforms Act, which was created by First Amendment after Kameshwar Singh Bihar's case, then many other laws were put into that ninth schedule. And it says that any law which has been put under ninth schedule cannot be challenged in the court of law as violative of fundamental rights. But Supreme Court in Coelho's case said, no, it is subject to challenge. We don't admit. If it is violative of basic structure, it is subject to challenge. In Keshwanand Bharti case, it was asked, Sir Sirvai, who was representing Maharashtra government, sir, let us know what is basic structure. Where should we locate the provisions? Which provisions we cannot amend? The parliament must know that, yes, this is a provision which is sacrosanct. You cannot, the court said no. We cannot define or we cannot confine the concept of basic structure. It will depend upon case to case. And they highlighted certain essential features of the basic structure. So Justice Palekar, who was in minority, gave a very important comment that basic structure doctrine, one of the finest judgment I came to read, is a twinkling star up above the constitution. So what Supreme Court says is a basic structure. They will decide finally whether a particular law meet the requirement of the basic structure or not, and what they say is a basic structure. So this is what happened when, I remember, Sapru, Tej Bahadur Sapru, who was constitutional advisor to the Constituent Assembly, he went to USA and he met the president. I think it was Roosevelt at that time. And he asked that we are framing our constitution. What is your opinion? They said, don't commit a mistake of writing word, the due process of law. So we coined a phrase in Article 21, the procedure established by law. And we avoided the phrase due process of law. Because Supreme Court said, the scholars have written that what is due process of law? Whatever Supreme Court vomits is a due process of law. So here also, whatever Supreme Court says is a basic structure. It's an essential feature of basic structure. Because it is nowhere demarcated, nowhere identified, nowhere. Supreme Court has said the balance and harmony between fundamental rights and directive principle is a basic structure. Now, where to derive that balance, how to measure that particular act has disturbed that balance or not. Anyway, that is a long story. It is a full book and I can speak hours together. and discuss. So time constraint is there. So there are many things. I think again the ninth schedule needs a relook. We have 285 laws in there. Even the seventh schedule, that is distribution of power, legislative power between union list, state list, and concurrent list. Also, there is a lot of haphazard. I have been reading it. I have been trying to understand. There is a lot of haphazard arrangement of the many entries are not there. Now we are facing this COVID-like situation, and there is no provision like this. So there are many such things. So again, I think we have to have a relook on the whole gamut of the distribution of the legislative powers. Friends, there are many such provisions, there are many such issues on which we need to have a fair, impartial, and balanced approach to our constitution. But finally, I would say, in spite of all the odds and aberrations which we have faced or which we might face in future, our constitution has done well. And in toto, suppose if you ask me, in toto, we have been able to sustain our constitutional democracy, our constitutional governance. Emergency and other few occasions are there where we could not meet those challenges and we resorted to the extra constitutional center of authority. But finally, it is the wisdom of the people of India. It is the collective wisdom of the people of India that we have been able to sustain our democracy, our democratic governance within the fold of the Indian Constitution. But yes, being a progressive state, we need to have a fair, impartial, experienced relook, revisit to our Constitution. And finally, as Honorable Justice said, I remember Franklin Benjamin, who was one of the founding father of the American Constitution, while addressing one of the convention, because after the Constitution was adopted, it was ratified by 9 states and other states were to ratify. So they wanted a Bill of Rights. So they were assured that yes, we will have Bill of Rights soon. So in next 4 years from 1791, the first 10 amendments, that is known as Bill of Rights, were enacted. So in one of the convention, Benjamin Franklin was advocating for adoption of the Constitution. Then one lady stood and asked, Mr. Franklin, what you have given to us? Franklin replied, a republic if you can keep it. So it is our collective conscience, it is our collective responsibility to maintain the sanctity and the effectiveness of this constitution, and also a periodic review. Though we have made, as I said, 104 amendments, but and 42nd and 44th amendment were like as larger or maybe larger than the total US Constitution. But it is a time, in my opinion, when we have crossed 70 years. It's a mature age. It's a we must have a dispassionate relook to the Indian Constitution. I once again thank the organizers for giving me this opportunity in the learned company of Honorable Justice B. Padmaraja sir, and thank you very much. All the best. Let our Constitution, let us salute our Constitution and let our spirit of Constitution live long. And let our Republic become stronger and stronger. Jai Hind, Jai Bharat.
Thank you, sir. Thank you for enlightening us on the topic. We have few questions, sir. If you would allow me to, shall I proceed, sir?
Sure, sure.
Okay, so it's a question. Your opinion on the Indian Constitution being described as the borrowed Constitution or bag of borrowings?
Borrowed or?
Borrowed Constitution or bag of borrowings?
Bag of borrowings.
Yes, sir.
See, it is true to some extent that we have our constitution. If you ask me, our constitution is largely based on, number one, the Government of India Act 1915, Government of India Act 1935. Then we have taken fundamental rights from Bill of Rights of US. Then we have directory principles from the Canadian and Irish constitution. Then parliamentary democracy is all of course, we have inherited from British parliamentary system. Then we have another provisions like fundamental duties which were incorporated by 42nd Amendment from Russia and Japan. So to some extent, we have major provisions like fundamental right, directory principles, duties, parliamentary system. And I don't think there is anything wrong in it. When we framed our constitution, we have several constitutions, several countries which are running constitutional governance. And if we can adopt certain good provisions, but the reservation policy is our own, these democratic decentralization, panchayat, nagarpalika. Now we have cooperative societies as a part 10th B. As the cooperative societies are part of the Indian Constitution. So these are our own requirement of the society as a zeal for democratic decentralization, or what we call grassroots democracy. So it is partly borrowed and partly what we call desi, Indian, based on Indian needs, Indian ethos.
So the next question is, when the judiciary as a guardian of...
Sir wanted to say something. Sir, please, yes, please.
Including the word, that new word that is coined is basic structure, is also our own.
Yes. Yeah, correct. Yes.
It has been used. It has come in handy to quash the recent legislation made by the Constitution.
Yes, yes.
Because you said that judicial appointments are concerned. There was a judicial commission, which in fact recommended by even Justice M.N. Venkatachalaya also.
Yes,
constitutional review.
Yes,
so this has come in handy. So far the basic structure concept is concerned.
Yes,
they simply quashed it.
So judicial
whatever new things which you want to bring into the Constitution can easily be quashed by using this coin, that is basic structure is concerned.
Yes.
It is not to be found in any other constitutions.
No, sir. No. Nowhere. No, there are certain unalterable provisions in Constitution of Japan. But they have said, they have entrenched them in the Constitution itself. So they are entrenched provisions, that these provisions will not be alterable. But here the basic structure has nowhere been defined. Nowhere, it has not been identified or located. In one of my chapters, I have seen location of basic structure. Where should I locate the basic structure? Okay, please continue with the next question.
So the next question is, when the judiciary, as guardian of our constitution, is failing to perform the duties of safeguarding the fundamental rights of ordinary citizens, then what are the options for the citizens in such testing times to seek relief?
See, it is the judiciary which protects when there is an onslaught on our freedoms by executive excesses. Either it is the wisdom of the executive to correct itself, or it is the judiciary, courts, which will come to our rescue. So we have to remain dependent on the judiciary and the wisdom of the judiciary. And I tell you, this whole PIL strategy has given justice to the millions of the have-nots. Otherwise, they would never have gone to the Supreme Court or High Court. Instrumentality of PIL that has given court these writs mandamus or quo warranto or prohibition and like that, especially mandamus, which has protected or which has in fact enforced the basic rights of the citizen. So we have to have faith in our judiciary. We cannot go beyond judiciary. We cannot create a third institution. Ultimately, somewhere we have to put faith. Sir, I will share with you, Honorable Justice Venkatachalaya came to Rajasthan, Jodhpur, and we were instrumental in the formation of the National Law University, NLU Jodhpur, which is among first 4 or 5 law universities in country. So our society, Indian Institute of Legal Education and Research, was the facilitator, or I would say promoter, of the NLU Rajasthan, Jodhpur. So Justice Venkata Chalaya came there, and during a small luncheon meeting, which was organized by Justice Dalbir Bhandari, he was my teacher also, so at his place. So there I just dared, if you remember that at that point of time, there was a judgment that the terrorists in the Golden Temple who were made hostages will be given 50 gram of rice and 100 gram of dal. This was a Supreme Court direction. So I just dared as a young teacher that, sir, if you permit me, can I ask a question? He said, yes, young man, please. So I said, sir, is it the task of Supreme Court to pass such directions that how much thing will be given, what will be one bottle of water and all? He laughed. He remained silent for 1 minute, then he laughed. And then he said, very candidly, he said, I recollect, Mr. Bhandari, do you think that we are always right? No, we are right because we are final. So you have no option but to follow us. So we are not always right, but we are always final. So we have to trust the judiciary. There are some cases for which, if necessary, constitutional amendment can be done. Again, that will have to be tested by the judiciary on basic structure, touchstone. But we have to trust the judiciary. And as I said, by and large, judiciary has performed its task with all responsibility and seriousness. Certain failures are everywhere in every institution, in everybody's life. Yes.
Thank you, sir. Thank you so much. So further taking the session.
Even I have a question, sir. Sir, as you mentioned about that, now we are having reservation for the Muslim community. So why can't we have the same reservations like for the transgender? I know they are added in the OBC category, but why not separate? As in, like now, since we recognize that as a gender, we also release a form where we say others or transgenders. So why not a reservation as well? If not, then isn't it against our constitutional values, where our constitution only says that it does not discriminate against any sex, caste, or religion? But here we are.
No, we should thank the Supreme Court, Naj Foundation, and other cases that at least transgenders are recognized as human beings. Prior to that, their plight was and now they are free to write in the form. So this right has been recognized, and that is a good development on human rights front. But now, when you are asking about reservation, my submission is that please do not ask more for any type of reservation. Now it's a time that we should review the whole reservation policy. This is how tomorrow you are asking for transgender. Other day, the Brahmins are asking. In Rajasthan, the Brahmins are asking. The government has done reservation for economically weaker section. So there are only two communities. Either you are weak. Earlier, there was a reservation. We accepted. During last 70 years, we accepted that, okay, scheduled caste and scheduled tribes, they need reservation. But we have, in Rajasthan, there is a dispute. The Meena community, which is the most flourishing community in scheduled tribe. Most flourishing, the highest number of administrative officers, Indian administrative officers are from one single Meena community. So this reservation has caused a great harm to the unity of the country. Because of the uncontrollable, to a limited extent, for a limited purpose, this was okay. That was also perhaps the intention of the makers. But now the way in which the demand of reservation, the Gujar community, you must have heard, the Gujar community is asking for 5% reservation. The government, as a tool of appeasement, granted, but High Court turned down. But they don't listen. They put the life on ransom. Tomorrow, other community, Rajput community, Savarn community, other community, this community, everybody is asking reservation. And the point is, where are the jobs? You can get, now they are asking one step forward. Make reservation in private companies. Compel the Microsoft or Google or Tata TCS that they will give reservation because they are getting land, electricity, water from the state. Where shall we go? What will happen of merit? We can support them financially if there is a weaker section of society. We should support them by granting scholarship, by granting other financial assistance, but let them be capable. Let them stand. Reservation basically is a Baisakhi. Is a what you call a
Yes, sir.
support system which will not allow you to grow on your own merit.
Yes, sir.
That is why I feel that no more reservations. Already we have crossed 50% outer limit of
Yes,
Indra
sir.
Sahani's case.
50% now, actually.
Yeah.
Almost.
In fact, the Indra Sahani case also needs a review. This is what I feel. One may not agree with me. We can always have a disagreement on certain issues.
But sir, I also believe that since just because the judgment has been passed in 2014, before that, so much of injustice has been done to them that cannot be undone. So, in order to give them a relief, just for a relief sake, I'm not saying only reservation like you suggested just now. For the scholarship can be given, job opportunities can be given, but they have to be capable enough for that. So, for that capability, some support has to be given to them as well. They do not receive that support from their familyhood, but a government can do a better initiative for them to get that relief. Is what
Yeah, that is what I'm telling, that we can have lot of social welfare measurements, social welfare and other economic support system where we can help them. See, initially when we became independent and we wanted those neglected communities to come into the mainstream. So it was a direct, what you say, a direct action that immediately certain 17% or 13% seats are reserved. So you can get entry into the services, you can get entry into the legislature, and you can also be a part of the governance. Fine, that was okay for some years. But now after 70 years, you think a Meena IAS officer, his son is also getting reservation because he is a Meena, whereas he has all the better amenities of the life which perhaps you and me may not have in our life. So this is how we need, but it is not possible because on reservation, that is the constitutional politics I see. All political parties, all they may fight, but when it comes to 2 points, one is raising the salaries, they are always one, and second reservation, because they all consider these as their vote bank. So they would never say, no political party has a courage to say that it is a time we should review the reservation policy. It is, I think me and you or Justice Padma Raja can say that enough is enough. Now let us relook it. Because they will never say, no MLA will say. Because you think that this is a easy, soft vote bank.
thank you so much, sir.
That's the reality. That is the reality
Yes,
we
sir.
see in life. Okay. So
Thank you, sir. Thank you so much for.
my pleasure. My pleasure. I enjoyed the session.
So, moving further, I would like to invite Nishchita, head coordinator at Law Internships, to take over the session.
Thank you, Riddhi. Today, we are not only celebrating our Constitution Day, but also the launch of our Law Journal and new vision to open online law school with the new Law Internships logo. The details will be given by Mr. Abhishek Castro. Over to you, Castro.
Thank you so much, Nishita. So, before introducing our journal and objectives of the journal and then the journal area of focus, I want to say how we worked so hard for the past 1 month in designing the journal. And then we have designed the journal cover page, and then how the designing committee of law internships and the law internships advisory and then the journal committee, how we worked so hard for the past 1 month in materializing and then bringing this design of this law journal into reality. So it's really, I want to thank the entire team Law Internships for your ideas and insights and inputs for making this journal launch a successful event. And we suddenly, after finishing all these works of journal designing and everything, we decided to launch this journal on the day of the Constitution Day, the National Law Day. And this is also an added feather to the cap of the journal launch plan, what we had. And now I will read the name of the journal. The name of the journal is Aperio Jess. Objectives of the journal. The Aperio Jess Law Journal represents national publication outlet primarily focused on UG and PG law students, faculties, academicians, advocates, research scholars throughout India and abroad. The purpose of journal is to publish high quality, double blind, peer reviewed legal research among all areas of law. The journal also welcomes pedagogical research, recent case studies, and then research papers, articles, studies, book reviews.
Abhishek, you just got muted. Abhishek?
Recognizing the academic publishing for law-related research among law faculty and practitioners has historically utilized and continue to use primarily the law review process for publication. Our journal represents one of a very small minority outlets for those who wish to publish utilizing the peer-reviewed process. Our journal will publish its books in volumes periodically with ISSN number. Our motto is to launch the journal in international standard. Journal's area of focus, our journal will be focusing on all areas of law. And this journal is not only going to focus into India. This journal is going to focus in the international arena, at the same time India. And I today resolve and swear we will make this journal to an international standard, welcoming research papers, articles, book reviews, case studies, and all the intellectual analysis made by them from abroad and from India. And I am very much happy to initiate this in the presence of Honorable Justice B. Batmaraj, former Judge, High Court of Karnataka, and my mentor and great guide, Professor Dr. M.K. Bandari sir, CEO of IELTS India. In their presence, we are very much happy to initiate this journal. With their hands, with their initiation, I am damn sure this will be an international renowned journal one day very soon. So now I request Ms. Nishita to play the video of the journal launch.
Could you please take some screenshots and share with me later on for my record?
Yes, sir. Yes.
Yes, sir. We'll share it to you.
How much more time you would take now?
Just 5 more minutes, sir. That's all. We're just going to wind it up. Sir, I hope you liked our cover page of the Law Journal.
Yes, definitely.
Thank you so much, sir.
Uh,
Officials, The PM represents Prime Minister, isn't
No, sir. It's my grandfather's and my father's name. That's all.
it?
uh,
Just on the lighter vein.
No
yeah,
issues. No issues, sir.
we convey, with the permission of Justice Padmaraja, we convey, both of us convey our best wishes for your new venture, and we hope you will maintain the same spirit which you have exhibited today for years to come, and pursue the path and with all inclusiveness, and bringing more and more members and students and learners to your fold. If we can be of any help and assistance to you, it would be our pleasure to support you in this venture.
That's exactly what I wanted to say.
Please,
We
sir.
are at the disposal of the organization.
Thank you so much, sir. And I'm definitely sure that our law journey is going to be a huge success for us. Thank you. So, as all good things come to an end, so is today's session. Now, I would like to call upon Ms. Simi Varghese, Corporate Relations and Event Head at Law Internships, to propose the vote of thanks.
She has
Thank you.
troubled me a lot.
Thank you, Nishchita. Once again, good evening, everyone. So I'm vested with the task of rendering the vote of thanks. So without much ado, let me begin with my expression of gratitude. I, on behalf of my team and the entire law internship management, express our wholehearted gratitude to everyone present here. To begin with, I express my sincere gratitude to Honorable Justice B. Padmaraj, sir.
A privilege.
So we were really honored to have your presence here, and I must say this was such an enlightening session for us. Thank you for walking us down the lane to understand what duty we hold towards the Constitution. Thank you very much, sir. Now I take this opportunity to express our gratitude to Professor Dr. M.K. Bhandari, sir. Thank you very much, sir. Our entire lives we spend in our present day, but once in a while it's good to look back into our past. And this is where Professor Dr. M.K. Bhandari has took us to, because we almost forgot that why was the Constitution made? Why was it brought about? And so you have beautifully explained to us that where we lag, because sometimes it has been a discussion among us students as well, that we have never, like our framers of the Constitution, we never have a longer vision. Probably it's that that some kind of obstacle to see into the future, that we don't have the necessary amendments that come up, but as you say, some trivial amendments that really needn't be there in the Constitution. Thank you so very much for this insightful session, and we shall definitely follow up all your further sessions that is to come with us. So with this, now, an event is never complete without the audience. So I thank all our beloved audience who took their time from their busy schedule to attend this and make it a point to listen to what both our honorable dignitaries had to say. With that, last but not the least, it is my team who had put in all this effort. So it's the law internship family who made sure that this particular day will have two eminent speakers to speak with us. And certainly, thank you very much, team. Thank you, and have a pleasant evening, all of you.
Thank you, ma'am. Thank you, everyone, for joining us in today's session. Thank you.
Thanks from our side also.
Let
God
me
bless
take
you.
leave of you.
Yeah, God bless
Thank you,
you.
Professor.
I hope Justice Padmaraja sir, we will connect and we will continue our dialogue.
Please.
And
It will be my privilege.
learn from your vast experience of judicial career.
Thank you, Bhandari sir. Thank you so much.
My
So
pleasure. My
actually,
pleasure.
we are planning for some talk series that we want to bring about. So we are planning on a series of sessions.